afternoon, everyone, and welcome to the next in the Compass webinars aiming to consider the effect of the pandemic that's affecting us all. One thing that makes this different from other seminars given by lawyers is that we're discussing something that the whole world is experiencing. So although we hope we can give you some insights from our perspective, we're fairly sure that you've got your own. I am confident that my fellow speaker, Kay Springham QC, is going to be able to do that. As well as her extensive practice in personal injury cases, Kay's worked in the case sector for some time, being, among other things, the legal chair of the Fitness to Practice panel of the Scottish Social Services Council, which regulates social care workers. Kay is going to look at some general aspects of the pandemic and then consider both standards of care and regulatory matters. And I'm going to discuss the sort of claims that might arise in relation to care homes and how they might be pursued. As is traditional in all seminars, there's going to be some housekeeping issues. Not about fire alarms, I'm afraid you're on your own in relation to that, but in relation to questions. What we're proposing to do is to invite people with questions to use the chat function, which hopefully you can all have access to, and put your questions up. Now we'll see the questions, nobody else will. We know you're out there, although you, I think, can only see the two of us. We know that you're there watching. And we'll see the questions that you put up. So what we suggest is that if you put questions up, then we'll deal with them probably at the end, assuming we've got time. This session is being recorded, although obviously it's only the two of us that are being recorded, and the recording will be available on the new Compass website, which we would certainly encourage you to visit, and you can get the other seminars in this series there as well. So with those initial remarks, I'm going to hand you over to Kay for the first section of the talk.
Okay, well, thanks very much, Ranald. So I'm going to start by a sort of general introduction and also looking at some facts and figures in relation to care homes in particular. I mean, I think we're all familiar with the tragic story that started to unfold in relation to Scottish care homes, and a brief internet search will show many troubling headlines, including a recent story in the Sunday Post, which was headlined "Hospitals in 5 Scottish health boards sent patients into care homes after they had tested positive for COVID-19. The Sunday Post has been involved in an FOI process to obtain information. So, as I said, let's have a look at some of the facts and figures. The most accurate figures on deaths come from the National Records of Scotland. And the recent figures indicate that as at the 9th of August, there have been a total of 4,213 deaths registered in Scotland, where the novel coronavirus was mentioned on the death certificate. And if I can just share with you some information in relation to that, hopefully you can see on the screen a graph which is sourced from the NRS, deaths per week involving COVID-19, starting at week 32, which is the 22nd of March 2020, and then going on to week 32, which is the 9th of August 2020. And we can see the exponential rise in deaths peaking in week 17, which is in April, at 661 deaths. More than 3/4 of all deaths involving COVID-19 to date were of people aged 75 or over, which perhaps gives an indication of the disproportionate effect on a particular section of the population. Of those who died with COVID, 92% had at least one pre-existing condition, and the most common one is in relation to dementia and Alzheimer's disease, which was 31%. And again, that indicates that the elderly in the population have been disproportionately affected. Looking more specifically at the proportion of COVID-19 deaths in care homes, this rose quite sharply in the earlier stages of the pandemic. And by the 20th to 26th of April, there were more COVID-19 deaths occurring in care homes than there were in hospitals. Since early June, the number of COVID-19 deaths in hospitals and care homes has been broadly similar. And again, there's quite a useful graph from the NRS website, which I hope you can see on the screen now. Green is deaths in hospital, and the amber is deaths in care homes. And we can see round about the 20th of April, deaths in care homes started outstripping those in hospitals. The current NRS figures are that 46% of COVID-19 deaths registered to date related to deaths in care homes, 46% of deaths were in hospitals, and 7% of deaths were in the home or no other non-institutional settings. You may have heard also of talk of excess deaths, and the statistics are even more sobering when you look at that. Most excess deaths, that is, deaths over and above what would normally be expected, have occurred in care homes. Between the 16th of March and the 2nd of August, there were 2,349, that's 49% more deaths in care homes than average. COVID-19 was the underlying cause in 80%, that's 1,875 of those excess deaths. And it's estimated that that equates to about 1 in 20 of all care home residents in Scotland. It's more difficult to access figures on how many care workers and other workers in care homes have contracted the disease and either survived or succumbed to it. It's thought that more than a dozen Scottish care workers have died of COVID-19, and there are many more who have contracted the disease and may be left with after effects. It's estimated that around 1,300 elderly patients were discharged from hospital into care homes to make space in hospitals. As we've seen from the Sunday Post article, some were moved after they'd tested positive, some were moved into homes which had COVID-19 in them, some were moved into care homes without testing, and some were moved after a negative test but where they had been in a ward with COVID-positive patients. There's also evidence that where a care home resident developed symptoms, the home might not be able to get the resident transferred to hospital. The initial guidance from Scottish Government was, quotes, "It is not advised that residents in long-term care are admitted to hospital for ongoing management, but are managed within their current setting." That guidance is no longer available on the Scottish Government website, but presumably could be obtained under FOI. It's thought that fewer than 1 in 10 residents in care homes were admitted to hospital for treatment of COVID symptoms. Testing is an issue which has become extremely important as time has gone on. In the middle of April, the First Minister announced that all symptomatic patients in care homes would be clinically assessed and, where appropriate, offered testing for COVID-19. And around the same time, testing for care home staff with symptoms became available. It wasn't until the beginning of May that the First Minister announced that there would be testing of all residents and staff, even those without symptoms. And it's also worth noting in this context that on the 13th of May, the Lord Advocate announced that COVID-related deaths of NHS workers and residents and staff had to be reported to Crown Office, and that FAIs would be held where the law required it. Could just give a little plug for the webinar which our colleagues Murdo MacLeod and Emma Toner did on that very topic. Now, before handing back to Ranald, I thought I would just mention that there is some evidence that there are legal challenges already being made. For example, in Scotland, there have been media reports that the families of 2 elderly residents of a care home in Drumchapel are intending suing the home in respect of their deaths, and that was where a COVID-positive patient moved into the care home. In England, the relatives of 2 residents of care homes have raised judicial review proceedings against the Secretary of State for Health and Social Care, NHS England and Public Health England. The claimant's pleadings, extending to 95 pages, can be accessed online should you be interested in looking at them. And we would be interested, obviously, to hear from anyone watching if they are aware of other litigations. So, as I say, I'm going to hand back to Ranald now, who's going to talk to us about where claims might come from. Thanks, Ranald.
Thanks very much, Kay. It seems to me that one important consideration to have in mind at the outset is that not all of what we might loosely call protective measures have the same aim in mind. To that extent, this pandemic is probably quite different from most other scenarios that we come across in our usual practice. For example, there's guidance, rules and regulations, the aim of which is to prevent transmission of the virus in the community, social distancing. And we'll recall the controversy that arose when it seemed, at least, that the government was aiming for herd immunity. Whether or not that was ever government policy, if that is something that is to arise, and if it does have a desirable aspect, then it's not going to arise without a certain number of infections and deaths. The wearing of masks was controversial initially in the UK and still is in America, but then so is everything else. One argument was that masks were only really useful in the clinical context, but it seems clear enough that the main function of a mask, at least the masks of the sort that most of us wear, is to prevent the wearer from potentially infecting others. In other words, it may be that the protection of the wearer is not the primary consideration, which is contrary to what we would normally think of if we're thinking, for example, of personal protective equipment. Indeed, the clue is in the name personal. If we recall the EC Council directive in relation to PPE, it defines PPE as being all equipment designed to be worn or held by the worker to protect him against one or more hazards likely to endanger his health and safety at work. Then, of course, there are measures, the purpose of which is to reduce the risk and indeed the mortality of a particular group, that's shielding, which may of itself have little, or at least only a very general benefit to everyone else. And the benefit to the individual who is shielding is probably something that only he or she is really able to judge, given the potential effect on him. So it's not as simple as looking at a situation where there's something hazardous and what we have to think about is how we protect that an individual from exposure to that hazardous thing. Care homes also occupy a particular position with all of the tragic consequences that Kay's referred to already. They're not institutions dedicated to the treatment of people with this disease, in contrast perhaps to an ICU unit in a hospital. But at the same time, they have a population particularly at risk from the disease, and they may find themselves dealing with the treatment of residents who have it. One issue, of course, is whether residents who test positive are likely to go to hospital or remain in the care home. Now, for obvious reasons, this talk is not particularly heavy on case law. That's for a seminar further down the line, perhaps. But there is one case I thought I would refer to, which might be useful as a comparison. If I say the name of the case is Swift against Fred Olsen Cruise Lines, you'll probably have an idea of what it's going to be about. It's not about coronavirus, it's from 2016, which is before the virus even existed, of course. And it concerned a cruise operator's failure to implement its own norovirus outbreak and control plan on board a vessel. And it was held that it had failed to take reasonable steps to implement its own system and therefore was in breach of various obligations, including under the Athens Convention. Passengers were held to have contracted norovirus on the vessel, so therefore causation was established. But there must be distinctions. Well, perhaps if I say first there are similarities because you've got a contained environment, a bit like a care home. But there are distinctions because the risk of the virus was on board. And the pandemic is everywhere. If a passenger catches norovirus on a cruise, then this is probably because there's a specific outbreak that in that case the plan was there to contain. If a person catches COVID, it's more difficult to establish where they caught it. But obviously the perspective on that may change as the number of cases in the general population changes or reduces perhaps. When transmission was widespread, it seems inevitable that it was going to arise in some care homes. Now the transmission in Scotland at least and the UK is lower, is an outbreak in a contained institution such as a care home more likely to be because of negligence? Perhaps it's more likely to be the result of some failure to institute or implement a plan, as was the situation in Swift. Causation is going to be an issue in all claims, if there are claims relating to COVID. And I don't propose to say too much about that. It's already been covered in a seminar by Jeff Clark and Malcolm McGregor. But it is worth mentioning that there are bound to be similar considerations to those looked at by the Supreme Court in, for example, Williams against Bermuda Hospitals, a case involving infection in hospital and a variety of different factors that led to the harm. If the incubation for COVID is up to 14 days, and if an employee with, for example, unsuitable PPE develops the disease 2 weeks after an outbreak in a care home in which she's working? How does she prove that she contracted the disease at work? And the answer may be found in the material contribution arguments discussed in Williams. Maybe need to be evidence about the extent of exposure and what's been referred to as the viral load. But again, if there's little infection in the community, but an isolated outbreak in a care home, it may be possible to identify the source of the outbreak and whether there is negligence. It might be worth pausing just to note that word source, because unlike, for example, in a disease contracted from asbestos or maybe MRSA from a hospital, the nature of COVID transmission and the concept of tracking and tracing may be that the source really is an identifiable person. There might be a difference between a claim arising from, for example, the failure to provide PPE, which increased the risk of transmission, and a claim arising because an identified individual who was positive came into a care home. That probably leads on to difficult questions about vicarious liability, in the sense of whether somebody who knows they are positive but goes to work is at fault. And perhaps that's rare in the care sector, but it may not be impossible, and it would certainly give rise to difficult issues. In relation to what might be the basis for claims, obviously the failure to provide PPE may feature, but there'll be a difference between what an employee in a care home can expect and what a doctor in an ICU would need. Obviously, the doctor in that situation is looking after patients who may all have COVID, and therefore the purpose of the PPE is probably primarily to protect the individual doctor. And the PPE he's going to be given is going to be quite different. Well, as the worker in the care home may be looking after residents who are not known to have COVID, and therefore PPE may be more about generally reducing the spread of the disease. But then it may be that the care home worker is looking after residents who do have COVID. And again, that may have an impact on the nature of the PPE that they're supposed to be given, because it's about protecting them as well as the general transmission. Another factor that may arise in care home claims may be the failure to impose restrictions. We all know about the restrictions that are in place in relation to care homes, in relation to visiting, for example, or whether residents who are in the home can leave. And if they can leave, for example, for a necessary medical appointment, whether on their return they have to quarantine, just like travellers, for 14 days, perhaps restricted to a single room for 2 weeks. As far as employees are concerned, unless they live in the home and don't leave, it seems to me that they're likely to be the biggest risk to themselves, and indeed to bringing the infection back into the home. Leaving at the end of each shift and having the closest contact with residents when they return. It's a little hard to see that a rule preventing visitors coming to the home would be relevant to a claim by an employee who leaves the home each day anyway. Kay mentioned testing, and obviously testing is a big issue in relation to this pandemic. Employees working in care homes should no doubt be tested regularly. But going back to what I said at the outset, a test doesn't seem to me to be a measure really to protect the individual being tested, however much he or she might want to know the result. It is, in relation to any duty of care, I would have thought, primarily to prevent an infected individual from coming to work and potentially exposing others. So a failure to provide sufficient tests could give rise to a claim from somebody else being infected, subject to all of the issues of causation and no doubt standard of care, given the difficulties that there have been in relation to the availability of tests. Kay mentioned claims potentially being made by residents in relation to relatives of residents who have died in care homes. It's probably worth noting that perhaps obviously the duties are going to be different in relation to residents than in relation to employees. And by way of simply a comparison, in a county court case from Bristol from 2015, it was held, predictably I think, that the control of substances hazardous to health obligations were owed to staff, but not owed to a patient who contracted MRSA in a hospital. And I'm sure the same approach would be taken to a similar situation in a care home and in relation to COVID. Duties of care owed to residents may include similar or may include obligations in relation to PPE, although perhaps in a different context. Again, it will be about whether the failure to provide staff primarily with PPE was something that was related to the spread of infection within the home. Duty of care might also involve the requirement to follow government and other guidance. My guess is that most care homes most care homes do, and indeed probably do more cautiously than government necessarily requires. Duty of care is probably also going to require a plan to deal with cases if they arise, and therefore the failure to have a plan or the failure to implement it, such as in the Swift case, could give rise to liability. But the position of a care home with a resident who tests positive is pretty difficult. As Kate notes, there are difficult issues about whether they should go to hospital, or whether the same individual would have gone to hospital if they'd not already been in a care home. It does seem unlikely that the courts are going to second guess decisions taken in those difficult circumstances, other than in the cases of very obvious error. Finally, it's worth mentioning the potential for conflict of obligations owed to care home residents. There must be a conflict, it seems to me, between obligations to prevent the spread of COVID, which of course are probably owed to everyone, and obligations owed to individuals in a care home. If, as I mentioned, a person has to go into isolation for 14 days after leaving the home, how will that affect their mental health or their physical rehabilitation? If, for example, a resident has a fall in a care home, goes to hospital for treatment for that, and then returns to a 14-day isolation in his room, he may not be able to exercise or receive physiotherapy. Does the duty to take reasonable care to prevent the spread of COVID trump all other obligations to the individual? At the local level, does the obligation to the other residents in a particular home trump the duty owed to the one resident who has come back from the hospital? Because it strikes me that the resident who is in quarantine, having been in hospital, might be quite unlikely to be positive, particularly given the instance of the disease at the moment. So the harm that he or she suffers by not receiving, for example, physiotherapy is potentially real, but the harm that's prevented by being secluded is probably just theoretical. Again, these are going to be hard questions for a care home, and questions that it seems to me the court will be slow to be harsh in dealing with care homes, other than in the more extreme cases. My suspicion is that care homes are approaching all of these matters, as I say, very cautiously, and that may well be with the potential for claims in mind. Maybe that some of those watching this seminar have already given advice or been involved in giving advice to care homes about these very factors, and we would be interested to have any comments or questions from those with that experience. Mm-hmm. So with that, I'm going to pass back to Kay.
Okay, well thanks, Ranald. As you say, lots of really difficult questions there, and I think I'm only going to pose some more questions in the next bit, which is looking at standard of care and looking at that in the civil liability field and also in the regulatory context. So just looking at the civil liability side of things, it's perhaps obvious that the standard of care will depend on who is being sued and on what basis. And I suggest that we take as an example the following scenario. A hospital patient X is transferred to a council-run care home without being tested. Shortly after transfer, X is noted to be showing symptoms of COVID-19. The care home attempt to isolate X, who has dementia and has a tendency to wander around the home. Another resident, Y, whose room is close to X's room, develops symptoms and dies. Several members of staff develop symptoms, some require hospitalisation, but all recover. And I say, let's leave aside the issues of causation, because as we've said, that's been covered in another talk, and I don't diminish the difficulty of causation. But looking firstly at staff members, a case might be brought against the employer alleging a breach of the employer's common law duty of care. Now, as we know, the various regulations which exist to protect employees no longer impose civil liability, but the courts do look to the employer's statutory duties in considering the scope of the employer's common law duties. So, for example, assessing the risk. Ranald was referring to the plan. Was there a plan in relation to dealing with this evolving issue? Also under Regulation 4 of the Personal Protective Equipment at Work Regulations 1992, the employer shall ensure that employees are provided with suitable personal protective equipment where they may be exposed to a risk to their health or safety, unless the risk has otherwise been controlled. So the lack of PPE, as Ranald has mentioned, at least at the beginning of the pandemic, was an issue. So how will a care home employer in that context be judged if a care worker was not provided with PPE because the care home was unable to source PPE? Will it be sufficient for the care home to say, well, we couldn't get PPE, so we just said to our workers to carry on with the work, knowing that they were being exposed to a risk to their health? Might it be enough for employers to show what efforts they made to source PPE and that they had considered alternative measures in order to control the risk to staff? What about the relatives of the resident Y? Y decides to raise proceedings against the council who run the care home, the health board who operate the hospital, and the Scottish Government who laid down guidance to be followed in relation to discharge of patients to care homes. The basis of the claim is a breach of Articles 2, the right to life, and 14, the right not to be discriminated against under the European Convention on Human Rights, relying on the Human Rights Act and the Scotland Act 1998. I think we can all agree that the right to life is the most fundamental of all human rights, and it has been said that where that is involved, any decision must be given the most anxious scrutiny. The hospital which made the decision to transfer the patient without testing must surely have known that its decision posed a risk to those already in the care home. Will it be expected to show what anxious scrutiny it gave before making its decision to transfer? As for the Scottish Government, which was responsible for the policies and guidance issued, will it be sufficient for it to say, as it already has, that decisions on transfer of patients was a clinical decision and not something for which it has responsibility? And where do individual clinicians stand in relation to decisions made either to discharge patients without knowing if they were COVID-free or not to accept transfer of ill patients from care homes? In clinical negligence actions, the standard is, of course, that of the ordinarily competent clinician in whatever field they are practicing. There's been some concern expressed by professional bodies that the current standard of care does not provide sufficient contextual safeguards to defenders in a negligence action. Not unreasonably, there is a concern that by the time that litigation is heard in the courts, the context of the pandemic will to some extent be forgotten. We all know that although the courts do not judge with the benefit of hindsight, it is human nature to do so to some extent. Professional bodies have suggested that the government should be stepping in and providing greater protection to clinicians, as has been done in some 34 states in the US. We're not aware, however, of any proposal to alter the position in Scotland. And I will say just a little bit, I'm conscious of time, about the regulatory aspects. There's also been concern expressed by those representing healthcare professionals. In early March 2020, the chief executives of statutory regulators of health and care professionals issued a joint statement, the signatories including the GMC, NMC and the SSSC, where they said, amongst other things, that we recognise that in highly challenging circumstances, professionals may need to depart from established procedures in order to care for patients and people using health and social care services. We recognise that the individuals on our registers may feel anxious about how context is taken into account when concerns are raised about their decisions and actions in very challenging circumstances. Where a concern is raised about a registered professional, it will always be considered on the specific facts of the case, taking into account the factors relevant to the environment in which the professional is working. And we would also take account of any relevant information about resource, guidelines or protocols in place at the time. Clearly, anyone who faces regulatory proceedings will be judged according to the guidance that was in place in the time, but anyone who has looked for documentation relating to the pandemic will find themselves swamped by guidance, protocols and policies from various agencies, all of which have evolved over time, sometimes quite rapidly. It's not always easy to work out how the various documents fit together or to find the versions of the documents which were in place at the time. It'll also be important to consider how reasonable it was for the individual professional to be aware of all of this guidance, protocol and such like that was, as I say, being issued and evolving quite rapidly. The context in which the professional was operating is also crucial, but how easy will it be to paint the picture of what was actually happening at a time when many of our public services were firefighting this disease? As with civil liability, is there a case for providing some stronger protection for those facing fitness to practice investigations? There's some evidence that the public think that there is. The Medical Protection Society recently commissioned a survey which asked the public whether a healthcare professional making a decision to delay treatment due to inadequate PPE should face regulatory sanctions. 81% of the public agreed that a healthcare professional making this type of decision should not face sanctions. But as with civil liability, we're not aware of any moves on the part of government to provide any greater protection at this stage. So with that rapid canter through the issues in relation to care homes, Ranald, do we have any questions? Have you been monitoring the chat function? Have we got time?
Yes, sorry, we do have one question. I'm conscious that we are running slightly over. I suspect one of the benefits of this format is that people are free to leave if they've got something else to go to, and not only will we not be offended, but we won't even know. So if you agree, Kay, I'll maybe just deal with the question and we can see if we can do so quickly. The question's about the date of knowledge, and it's been asked whether there's an issue about the date of knowledge in relation to COVID claims in care homes, and whether there's a point at which operators of care homes would be said to have known of the risk such that they had to do something to prevent it. I don't know if you want to answer that, Kay, but for what it's worth, my own suggestion is that in Britain that may not be so much of an issue because we would already have seen what was going on in our European neighbours, in particular Italy, I think, where care homes were known to be an issue before the disease really took hold in the UK. So maybe that's not such an issue for claims in the UK, but I don't know if you've got any thoughts on that, Kay.
Yeah, I mean, I think that you're right, that obviously government certainly could be looking at what was happening worldwide. I'm not so sure in the position in relation to, the operator of an individual care home and what they will be expected to know. I think it is, as many things in life, it's fact specific. And therefore, it might well be reasonable to say that, well, government should have known and they should have been issuing guidance and didn't do so. But the individual care home operator, I think, is in a different situation.
Yeah, I can see that. And of course, there's also the issue, as shown in your graphs, of the lag between the time when infections are happening and therefore when things need to be done and the actual effect of those infections, even though it's obviously relatively short compared to something like asbestos disease.
Mm-hmm. Yeah, well, exactly. And I was also thinking that, there's potentially there's also a kind of issue of a kind of precautionary approach that, whilst there might have been a time when we didn't really know whether masks were any good or not, would the precautionary approach of the employer not be to say, well, if we can get them, why wouldn't we use them? Whether they ultimately provide the protection that's necessary is a different issue. Just on the question of PPE, I think there's another question about the cost of PPE and other precautionary measures for care home employees. Any thoughts in relation to that one, Ranald?
Well, I suppose, I suppose in relation to employees, if the obligation under the regulations is to provide suitable and sufficient PPE, then cost, I think if I'm right, in relation to the regulations, albeit that's not quite so relevant in the civil claim context, cost is only really an issue potentially, well, maybe in relation to suitability. It's suitable whether you have to provide the best that's available or just the best that you can afford. I think that is a factor that can be taken into account. So it may be either a defence or a potential ground of dispute. Would that be right?
Yeah, I mean, my thoughts on it would be that, I mean, in general, you know, the courts are not awfully sympathetic to an employer that says, oh, well, it was really expensive, so we didn't do it. But I do think that, you know, it is going to be a factor, isn't it? You know, when you look at the overall, the duty of reasonable care. I mean, I think a big issue is going to be about just actually resourcing PPE. And whilst, you know, the regulations, what the regulations say, I mean, you know, surely to goodness you have to take into account the fact that it just wasn't there, you know. But that might call into the issue about, well, were there other measures that could have been taken, and what did the employer think about in relation to those other measures that could be taken? Yeah, I think that covers all the questions that we've been asked, and thanks very much actually for people posing some questions. I mean, we have posed lots of questions ourselves, and I think that you know, that it is a difficult situation, and I'm sure that there will be litigation in relation to at least some of the issues that we've covered today. So I think with that, we can probably just thank everyone for coming along. As I said at the beginning, it's being recorded, so if you were wanting to watch it again or share it with someone, then it will be on the Compass website at some point. But other than that, just enjoy the rest of your day.
Thank you very much. Goodbye to everyone.
Goodbye.